Is it time for English law to embrace a duty of good faith in the performance of all contracts? What is good faith and how does it impact contracts? In short, good faith is a tool implemented within contracts in order to assess unfairness. According to Director General of Fair Trading, the First National Bank plc 2001, good faith is simply a formality in the upkeep of good standards of commercial morality and practice. Its impact on contracts differ, however. The common law system recognises a duty to act in good faith in certain types of contracts, for example, in contracts of employment or insurance. Commercial contracts are different yet again. In Yam Seng, Lord Justice Lega emphasised that the content of the duty to perform a contract in good faith is dependent on context. The Court of Appeal in Mid-Essex Hospital Services NHS Trust, the Compass Group UK and Ireland Limited, re-emphasised this and saw that in accordance to commercial contracts, good faith must be applied whereby context permits. This is also being seen in Section 62 of the Consumer Rights Act, subsection 7, A, taking into account the nature of the subject matter of the notice, and B, by reference to all circumstances existing when the right or obligations to which it relates arose, and to the terms of any contract on which it depends. This is, however, as seen in Bristol Ground Score Limited, the Intelligent Data Capture Limited, and others, a limited requirement of what could be named good faith within all contracts. That being, the honesty between the parties must at least be adhered to, whether honesty be classified under a good faith clause or not. Yet, in Yam Seng, the judge did state that there were two aspects of good faith, one of which including honesty, and the other being fidelity to the parties. Meaning, it could be argued, in taking Lord Justice Legatt's precedent alongside that seen in Bristol Ground School Limited, the Intelligent Data Capture Limited, good faith is already largely implemented in all contracts, significantly commercial. The current status of good faith's enforceability within courts. Good faith is present in most legal systems, and it's also seen in many EU international texts, but is still misunderstood and controversial. A large issue of causing the confusion is due to it remaining an undefined implementation. Currently, the UK does not have a general obligation of good faith within our courts, largely due to the fact it is not enforced by law. Although this standpoint has been heavily criticised by those such as Lord Justice Legatt and Yam Seng, stating that the UK legal system is swimming against the tide in relation to implementing an obligation of good faith. However, Lord Justice Legatt's standing was quashed during the case of Mid-Essex Hospital Services v Compass 2013, due to the lack of an official doctrine for good faith, which appears to be a shared opinion between many legal professionals within the UK. When it comes to express terms of good faith within a contract, the courts will give effect to the parties' intentions. However, it will not be seen by courts as implicitly meaning a general rule of good faith. This restrictive approach is presented by the Court of Appeal's decision in Compass Group UK and Ireland Limited, the Mid-Essex Hospital Services NHS Trust 2012, whereby the court refused to accept the clause of good faith as a general obligation, holding that the obligation was in fact only relative to the specific circumstances outlined by the clause. This was re-emphasised in TSG Building Services plc v South Anglia Housing Limited, through which the clause stated that both parties must work in a spirit of trust, fairness and mutual cooperation, and which also required the parties to act reasonably. Its impact on the contract was quashed by courts and was not considered to be a breach when one party acted upon their right to terminate the contract. Therefore, although present, the enforceability of good faith within the court is extremely limited, and other terms, as seen in TSG Building Services v South Anglia Housing Limited, taking precedent. the argument to either embrace good faith and the possibility of establishing an official doctrine. This would then encompass all contracts in the obligation of good faith, or to continue as we are in respect to good faith and as mounting fears of consequential instances if good faith were more prevalent in the law of contract. In favour of good faith. There has been some development within courts in respect to embracing good faith as a general obligation. This can be seen in the following case law. Recently, through authority within English courts, it has been suggested that in circumstances of contractual discretion, proceedings should be carried out with good faith. In Abu Dhabi National Tanker Company v. Product Style Shipping Limited, Lord Justice Legat found that where a discretion is granted, not only must the discretion be exercised honestly and in good faith, but having regard to the provisions of the contract by which it is conferred. It must not be exercised arbitrarily, capriciously, or unreasonably. Therefore, meaning that if stated in express terms agreed upon by both parties, a good faith clause must be adhered to in a non-arbitrary manner as set by the precedent established by Lord Justice Legat. Another influential case was Braganza v. BP Shipping Limited, where the Supreme Court established the duty of rationality, thus creating the Braganza duty. This case re-emphasised that stated by Lord Justice Legat, as well as creating a more effective method of enforcing good faith, i.e. the Braganza duty. Arguably, the most significant case in the enforcement of good faith within courts is Yang Seng PTE Limited v. International Trade Corporation Limited 2013, whereby the High Court discovered an invocation of a good faith term had been breached. Lord Justice Legat concentrated specifically on relational contracts in his decision, where he found that contracts of this nature had likely implied a term of good faith. The case was taken to the Court of Appeal, where it was cautiously approved, thus meaning the decision by Lord Justice Legat created an authority that in cases where the contract is relational, there is an implied duty of good faith. Critiquing good faith. There are some legal professionals who disapprove of the possibility of establishing a good faith doctrine. This is seen in MSC Mediterranean Shipping Company v. Cottonex 2016, whereby the Judge Morbick, Lord Justice, relays his fears due to the dangers of the general principles of good faith, stating it would be invoked as often to undermine as to support terms. There has also been a reluctance from English courts in the recognition of a general obligation of good faith in commercial contracts. This is mainly due to the fact good faith brings a level of uncertainty, which the law of contract constantly works in depleting in English law, therefore not wanting to take a step backwards if not necessary. The reason for its uncertainty is largely due to the fact the obligation is non-specific and often subjective, hence why many judges saw to good faith only being enforced in very context-heavy circumstances. Good faith is also seen as being contradictory to the very foundations of freedom of contract. Courts don't see a reason to meddle where parties have freely decided upon terms and would impact freedom of contract by enforcing a general principle of good faith. As established by Lord Justice Legat, by law, there is an implied duty of good faith within relational contracts. However, academics have criticised this due to the uncertainty around whether a contract is definitely relational. This view has been seen within the justice system, with courts being slow to accept the concept of relational contracts. For example, in UTB LLC versus Sheffield United Limited, the reverse method of implied good faith used by Bates was criticised by High Court. Mr. Justice Farncourt stated that the test must be established for that of relational contracts and should only begin with looking at express terms. and should only be used for commercial or practical clarity. However, although stated in law that relational contracts have implied duty of good faith in using the Braganza duty, in TAQA Britannia Limited v. ORS v. Rockrose, His Honour Judge Pelling highlighted that in this particular case, the joint operating agreements, which had been argued to be a relational contract by the claimant, was in fact a relational contract due to it being incredibly detailed, due to it being drafted by professionals. He said, therefore, the starting point and in all probability the end point in the construction of the exercise will be A, the natural and ordinary meaning of the provision being construed, B, any other relevant provisions of the contract being construed, and C, the overall purpose of the provision being construed and the contract in which it is contained. Thus meaning that due to the great deal of detail of terms outlined within the contract, there would be no ambiguity in how both parties should behave. Therefore, the need for a court intervention through a good faith clause was not needed, and breach of contract was done knowingly, if at all. Therefore, should English law embrace good faith? There is no way to correctly predict the implication of good faith into the law of contract, let alone the scope of obligation of good faith, especially in particularly complicated contracts such as commercial. It is unknown whether the view of Lord Justice Legatt will be largely shared in coming years, or fears of uncertainty will halt good faith in its tracks. Currently, it is a majority opinion that good faith should remain as a discussion point at the time of drafting, and to only be implied and added as an expressed clause. Thus leaves the court and parties in a clear and mutually agreed upon standpoint if a breach were to occur. If this opinion were to change, however, the likely changes to make good faith more enforceable should be 1. Establishment of a legally binding agreement, 2. Creating of an expressed term rather than an implied term, and 3. Allowing a system of objective analysis by a third party. After analysing both sides of the argument, it is not time for English law to embrace good faith in the performance of contracts. It appears to be the fear of many that it could underpin not only terms of the specific contract, but also contradict the foundations of freedom's contract. English law of contract is also world famous for its certainty, where introducing good faith as it stands currently would most definitely impact the reputation due to its undefined manner, as well as it being vague and subjective. There are also provisions in place currently for instances where good faith clauses are of positive impact, such as the use of good terms in being an overarching rule in civil contracts and the authority set by Lord Justice Legatt in relation to relational contracts. If good faith were to be defined, perhaps it could be established as a general principle. However, its nature is for it to be contextual, making it very difficult to establish.